Hi everyone, in today's video, we are going to explain a little bit about the history of Indonesian law. So sit back, relax, and enjoy the video. To fully understand Indonesian law, it is insufficient to look at its current state. To do this, we have to go back to pre-independence Indonesia where the Dutch colonized the archipelago. In fact, Indonesia's legal system that is implemented today is significantly influenced by the country's colonization history. Upon Indonesia's independence, exactly a day after its proclamation, the Indonesian government established the 1945 Constitution as the basis for Indonesian laws, by which every law and regulation should be made in compliance with it. However, at this time, the Indonesian government had not implemented any of its own laws to regulate its citizens. Considering the legal vacuum it could create, which may lead to civil unrest and societal imbalance, the Indonesian government invoked the transitory provision within the Constitution. It provides that every law and regulation which were in power before the war, given that they do not contradict the spirit of the Constitution, are applicable unless it has been revoked or replaced by a new law by the Indonesian government. It is obvious then that the transitory provision provided the means through which the colonial legal system can be revived. However, the provision also gave that this legal system must be adjusted in accordance with the Indonesian legal framework. For example, the Dutch established legal pluralism in Indonesia based on its discriminatory principle, but was revoked by Article 27 of the Indonesian Constitution, which deems every Indonesian citizen as equal before the law. Accordingly, legal pluralism still exists today in Indonesia, but its discriminatory spirit has been eliminated in accordance with the legal framework in Indonesia. Therefore, it can be seen that the colonial legal system played a chief role in creating the legal system we know today in Indonesia. In fact, the Indonesian contemporary legal system would not have existed if it weren't for the colonial legal system. Among the most influential Dutch provisions that are still applied up to today are regulation of judiciary and the policy of justice, general provisions of legislation, civil code, commercial code, as well as the provisions on crimes relating to bankruptcy and insolvency. These laws were passed by Royal Decree of May 16, 1847, and then became the foundation of the colonial-made constitution called the RR. The RR patterned the Netherlands constitution but was made specifically for the colonial administration occupying Netherlands India.
The legal system in Indonesia during the Japanese occupation. During the Japanese occupation, the implementation of governments in Indonesia was guided by a law called Gansire through Osamusire. Osamusire regulates everything necessary to carry out the government through an implementing regulation called Osamukanre. Osamusire rules apply in general. Osamukanre, as an implementing regulation, it also regulates the matter need to maintain security and public order. In the field of law, the Japanese Army government through Osamusire No. 1 of 1945 in Article 3 states, all governments, agencies, and their power, law, and law from the former governments are still recognized as valid for a while, as long as they do not conflict with military government regulations. Based on Article 3 of Osamusire, it is clear that the law and regulation that were enforced before the Japanese Army came to Indonesia are still valid. This Article 131 IS as a political law article and Article 163 IS, which regulates the division of population group, are still valid. Therefore, in effect, during the Japanese occupation, there were not many fundamental changes to the legal system in Indonesia. Japan is more focused on population mobilization in Indonesia for the Japanese interests in World War II. As a result, the Dutch system still applies in Indonesia. Therefore, Indonesia entered the civil law system. Civil law system is a legal system that originated in continental Europe and was adopted in the most part of the world. The civil law system is characterized within a framework of Roman law, and with core principle codified into the referential system, which serves as the primary source of law. Civil law systems are often contrasted with the common law system.
The currently applicable constitution governing the Republic of Indonesia is the 1945 Constitution, which has been amended 4 times after the downfall of the New Order regime. However, before the 1945 Constitution was officially implemented, Indonesia underwent major changes in terms of its constitution, like for example in 1949 and in 1950. In 1949, due to the pressure from the Dutch government, which sought to retain power in the archipelago after the war, the federal constitution was enacted, drastically changing the form of state of Indonesia from a unitary state to a federal republic of Indonesia, or more often called as the United States of Indonesia. In 1950, the unitary state of Indonesia was reinstated through the establishment of the Provisional Constitution of 1950. It lasted for just 8 short years, and due to the shortcomings faced during the first general election in 1955, the 1945 Constitution was officially implemented again in Indonesia.
The 1945 Constitution consists of preamble, 16 chapters, 37 articles, 4 transitory provisions, 2 additional provisions, and an explanatory section. In the Sukarno regime, it was enacted with the application of guided democracy, where a mechanism by which all state institutional decision-making could be decided through a musyawarah mufakat, or in other words, discussion to reach unanimous agreement. If it could not be agreed, it should be given to the leader to decide. In reality, guided democracy enabled President Sukarno to control all decision-making process. The reform era brought about amendment to the 1945 Constitution, which was previously considered as a sacred book. Article 7 of the original version of 1945 Constitution was a point of entry for amending the no longer considered sacred book. The article prescribes that the Indonesian presidents hold an office for a 5-year tenure and may be re-elected for the consecutive term. In the original version of the Constitution, however, there is no single provision specifying presidential term limitation. The absence of such a provision in the original version of the 1945 Constitution led to constitutional manipulation by those who held the power. Despite delicate performance in terms of not violating Article 7 of the 1945 Constitution, New Order administration under has practiced political engineering. His handpicked members of the People's Consultative Assembly had installed him as a president for 7 consecutive terms. Students who staged rallies every day since mid-1927 demanding political, economic, and law reform then forced Suharto to step down. Due to such manipulation, it was agreed upon by the post-Suharto People's Consultative Assembly that the 1945 Constitution was made at the plenary session of the 12th General Meeting of the People's Consultative Assembly on October 19, 1999. Fourth Amendment to the 1945 Constitution was adopted at an annual meeting of the People's Consultative Assembly of 2002.
Thank you for watching this video, and we hope that it has been helpful for you guys to understand more about the history of Indonesian law. Bye now!